Who are the real super predators? This is a synopsis on how politicians, attorneys, the courts, banks and other corporations are able to steal people's homes, incarcerate them and/or sentence them to life or to death. More details on how this is done are provided in my other videos. Before an attorney can file documents in a court case, the attorney must file an appearance of Counsel Form AO 458 or a similar document along with a mandated certificate of service electronically and not by paper with the clerk's office. The failure to sign and file valid forms means you, the individuals, the corporation, etc., were never represented. This is called simulation of legal process. AKA I took your money but never represented you. The Illinois Northern District Court came up with its own attorney appearance form which has not been approved for use by the Administrative Office of the U.S. Courts. Therefore, they cannot say that they did not know that the form was being used for nefarious purposes because they created it. The first thing I want you to be aware of is that the conspirators want you to believe that /s or s/ is a valid electronic signature when in fact /s/ is a valid signature. Per the ILND Court's mandated rule on electronic signatures, the attorney logged into CM/ECF must be the same attorney whose name appears on the signature line. The electronic signature, typed at the signature line of the document, consists of the characters /s/ and the attorney's name typed out. For example, /s/Ted Newman is a properly formatted electronic signature. The s/ before the signature line is pre-printed on the form. Let me say that again, it is pre-printed. It was not typed by hand by the attorney who filled out the form. It should not be there. Its sole purpose is to serve as a distraction to trick non-attorneys and non-conspirators into believing that the form was signed. The attorney who filled out the form is fully aware of this because they did not type the s/. When I type my name after the pre-printed s/, I am doing just that, placing my name after the pre-printed s/. I did not sign the document electronically. Do you see? When I type my name, the text box disappears and a blank signature line appears. This document was not signed. Now I will show you a valid electronic signature. I type a/ then as then another / followed by my name again. The text box disappears leaving a signature line. This is a valid electronic signature. I will now use a cursive /wet/ holographic signature to sign the form. This is a valid signature. A person of average intelligence would hypothesize that an attorney does not want to sign the document because they are required by law to do so under the penalty of perjury. Some attorneys will sign the form, however, they will leave out the key words under penalty of perjury. The use of valid forms is paramount because a corporation such as a bank and a criminal defendant must be represented by an attorney. If a document was / is not signed by an attorney, the judge was / is required to dismiss the case. See the Federal Rules of Civil Procedure Rule 11. Federal Rules of Civil Procedure Rule 11, signing pleadings, motions, and other papers, representations to the court, sanctions, a signature. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally. If the party is unrepresented, the court must strike an unsigned paper unless the omission is promptly corrected after being called to the attorney's or party's attention. An attorney appearance must be made prior to or simultaneously with the filing of any document. Local Rule 83.12. Appearance of attorneys generally states in part as follows. Who may appear? Only members in good standing of the general bar of this meaning the ILND court may enter an appearance on behalf of a party, file pleadings, motions or other documents, sign stipulations, or receive payments upon judgments, decrees or orders. Attorneys admitted to the trial bar may appear alone in all matters. Attorneys admitted to the general bar, but not to the trial bar, may appear in association with a member of the trial bar in all matters and may appear alone except as otherwise provided by this rule. The judges of the Illinois Northern District Court and Seventh Circuit Court frequently awarded attorney fees and monetary awards to lawyers and their corporate friends even though no attorneys filed an appearance of counsel along with a certificate of service. Even if the attorneys had filed an appearance of counsel or another valid document along with a certificate of service, which they did not. Most of the attorneys shown above are not members of the trial bar, meaning that they could not appear alone in a court case. Including but not limited to the attorney, for Michael Madigan, PNC Bank, the American Bar Association, the University of Chicago, Northwestern School of Law, Google, Starbucks, PepsiCo, Shellpoint, Wells Fargo, Lyft, Groupon, Southwest Airlines, Bank of America, the Bank of New York Mellon, Chase Bank, Walmart, etc. They could not serve as lead counsel, yet, a lot of them checked the box stating that if the case went to trial, they would appear as lead counsel. 2. ILND Local Rule 83.12 states as follows. D. Waiver. A judge may permit an attorney admitted to the general bar, but not the trial bar, to appear alone in any aspect of a civil or criminal proceeding only upon written request by the client and a showing that the interests of justice are best served by a waiver of these rules. Such permission shall apply only to the proceeding in which it was granted and shall be limited to exceptional circumstances. No such written request was given to the attorneys. This means any document that was filed by an attorney who did not follow the above rules is void without legal effect. Any alleged orders that were given even by the U.S. Supreme Court are void without legal effect. After the attorney has made a significant amount of money, which is usually several years down the line. Most of their billion-dollar profits come from taxpayers. The attorney will file a simulated motion to withdraw. The problem is that you can't withdraw from a case in which you were never the attorney, even if a valid appearance had been filed. There are a host of local and federal laws that must be followed before an attorney can withdraw from a case. Notwithstanding the foregoing, the judge will usually issue an unlawful simulated ruling granting the request anyway. This is because most top government officials and state and federal judges are former employees of top law firms. Most were partners of these firms, therefore they knew or should have known of the corruption taking place in their firms. A supervisor is responsible for the actions of its employees. Now they run the government demonizing blacks in order to take the light off of them. The following officials are former employees of Kirkland & Ellis. Brett Kavanaugh, former White House counsel Neil Eggleston, former appellate court judge Robert Bork, Ken Starr, and various Trump administration officials, including former National Security Advisor John R. Bolton, Attorney General William Barr, former Secretary of Labor Alexander Acosta, and Secretary of Health and Human Services Alex Azar. The attorney representing the plaintiff and the defendant often work together. Trust no one. And check to make sure that the attorney you paid for in a civil case such as a foreclosure and that you may or may not have paid for in a criminal procedure signed both forms properly and complied with the law. Another common trick is the failure to issue summonses that do not contain a signature and/or seal of the court. Do you see why there is such economic and racial disparity in this country? Some of these attorneys, like Hitler, believe that certain groups of people are inferior. This was just a small sample of the unsigned attorney appearances that can be found in the Illinois Northern District Court. Be aware that similar practices takes place in other state and federal courts. Who are the real super predators? Who are the super looters?